Today, we're going to cover a very basic topic. One thing that people are very surprised about when they start working on ediscovery is redactions. It seems kind of weird to them, like, wait, what? People like blank out parts of a document and that's legal? What's going on with that? That seems weird. And so every time I have to explain to them. So in order for me not to do it over and over, we're going to talk about in this video. Quick disclaimer before we start. I'm not an attorney, so what I'm sharing with you is basically what I learned through my job being a tech person. So this is just kind of a surface, top-level overview. So during litigation, after parties have done looking at their documents, they exchange documents between each other because both sides need to be working with the same documents when the trial starts. Part of the process of production is redacting portion of a document so that the other side doesn't see certain information. In my experience, there are three major reasons for removing content of a document so that the other side doesn't see it. And the first one is client-attorney privilege information. You may know that certain communication or certain information has additional protection applied to it. So for example, whatever you discuss with your doctor or your psychologist, and in this case, your attorney. Anything you tell your attorney is between you and him. No one else has rights to see that information. And so because of that, when you exchange information with the other side, anything you tell your attorney, you're allowed to exclude from a production. Easy example of that would be, let's say you expect a litigation and you may want to ask attorney, what kind of danger am I in? You know, how liable I am, what kind of damages I can expect to pay, things like that. And this information is no one else's business besides you and your attorney. So this has completely valid legal reason to be blanked out from a production. Now, interestingly enough, I heard of this case where some companies try to take advantage of it, so they have to produce as little as possible. So what they did is they worked with their attorney and they said, create an email account for us, right? So that's just for our company. And what we're going to do is whenever internally we discuss some kind of sensitive topic or something we could get sued for, we'll just CC that email. And then whenever, if something happens, we don't have to produce those documents. Now, I don't think that actually held up too well, but that was kind of an interesting idea. Just anything that's questionable, just CC your like a dummy account at your law firm, and then you can claim like, hey, this whole document's attorney-client privilege, so I don't have to share any of that. And the second reason I've seen documents get redacted is if something is confidential. Let's say you claim you didn't get paid fairly, or there was some kind of issue with how you're being treated and you're not getting the salary you deserve. Well, maybe you request company to turn over certain payroll documents, but the information about how much the CEO of the company makes, well, that could be considered confidential and it's not really relevant to the case. So that spreadsheet from human resources may have that information redacted because that's a company's confidential information and no one else really needs to know about that. Now, the third reason for redaction that I heard about is trade secret. So let's say a company like Coca-Cola, they discussing formula for, for their various drinks, Coke, Sprite, whatever other drinks they have in their email communication. And there may be a case that's relating to just one of those particular drinks, let's say formula for Sprite. Well, they don't want to include formula for Coke on that email chain and produce it because that's their trade secret information, right? They don't want to share it with the world. Other situations may be if a company uses like some kind of machine that's proprietary that does certain specific thing, like a tool that they've built that does certain type of stitch and leather or whatever. There's some proprietary machines that people actually don't apply for patent for because they don't want the world to know. So if there is a case, they don't want that information to be shared with the world because, again, it's their trade secret, that's proprietary thing that they've developed and they don't want information to be available to others. So those are the three common reasons that I've seen in my experience. And the next question comes up is like, well, so the companies can just redact what they want and basically everyone has to trust that's what it is? And in some cases, kind of yes, and in a way, no. The other side could challenge those redactions. They could say, well, you know what, you overdo it on your redactions, you cover in something that is relevant to the case, and they may ask a judge to kind of overrule that, and that the whole arguing starts. So the redactions are never sort of final. The other side can always challenge it, and that's one of the reasons we have to redo productions with additional redactions, with redactions removed, with all kinds of stuff. It's because of all that. It's because someone's possibly abusing their rights to redactions and overdoing it, and then they're getting called out saying, no, 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 we need that information that you have redacted. So there you go. That's my fairly basic understanding of why redactions are being done and what is the reason behind it. If you want to be more descriptive on that, put it in the comment section below. Don't forget to follow on LinkedIn, subscribe on YouTube, and I will see you on another video.